While there's a lot of comments that your lawyer can and should be telling you prior to you two starting a working relationship together, there's also comments that in my experience, lawyers just don't share with their clients. In today's video, we'll go over 5 topics that your lawyer generally won't share with you. And after watching this video, you'll be equipped with the knowledge required to ask your lawyer about these 5 secret topics, and also be able to keep your ears up for if your lawyer is making certain kinds of comments. Well, are they ethical and are they appropriate of what the standards of conduct for lawyers are? As a lawyer myself, specifically a business lawyer, I certainly understand the reasoning behind why many lawyers, if not most, won't share these ideas or topics with their clients. However, I also am a big advocate for transparency and honesty in the working relationship with my clients. So to me, it's not really the case that any topics are taboo or I intentionally conceal when working with my clients. Now, if you're new to the YouTube channel, please go ahead and click subscribe and give this video a big thumbs up. Graphene Business Law is a law firm offering business law services and working exclusively with entrepreneurs and business owners in the province of Ontario in Canada. And on our YouTube channel here, as the founder and owner of Graphene, I post content multiple times a week that is free educational content for people just like you, business owners and entrepreneurs. It takes a lot of time to put this content together, so I'll give you a second to give this video a thumbs up. Now, the first thing your lawyer isn't going to tell you, and that this one is actually something that they can't really tell you, and if you do hear it coming out of a lawyer's mouth, I would actually consider it more of a red flag, is a guarantee as to whether you'll win a case or not. Is a definitive percentage or chance, likelihood, however you want to describe it, of whether you can win a case or not. And the reason for that is because your lawyer is not the one making the decision of whether you win or not. If I can make a decision on whether my clients win their case or not, don't you think I would decide 100% of the time that they win? But it's not in my hands. Depending on the case at hand and the subject area, that decision maker will either be a judge, and depending on the level of court, that can be multiple individuals, or it will be a jury. And we've all seen the movies, you know, a jury is comprised of a body of individuals, multiple people that make a decision as comes to the case they've heard and the sides at hand. Now, when I was in law school, I remember it being said to me by a very, very well-reputed law school professor cited all over the Commonwealth jurisdictions that the best case, the best book closed sort of case, has an 80% chance of winning in court. And why is that? Because the best case is still coming across the desk of a human being that is your judge. That human being, and I'm quoting my professor here, could have had a bad breakfast that morning. He could have gotten in a fight with his wife that morning, or she, or whatever gender that judge prescribes to. They could have had their own issues by virtue of being a human being. And it happens. If it didn't happen, why would we have different levels of court? For example, courts of appeal and all of those levels. So all that to say that if a lawyer is prescribing a definitive chance to whether you'll win a case or not, I personally, as a lawyer myself, would consider that on the unprofessional side because it's not appropriate. They can't guarantee you anything. And you have no idea how loudly I say that to my clients because we're so used to all the movie crap of the closer, the finisher, all these whatever crap lawyer names and enigmas and all that. But there's no such thing like that in real life. There's nobody that wakes up and it's like, oh, big dog's in town, he's winning this case. No, if that was the case, then what's the point in all these lawyers working and all these judges and all of these different subject areas? That's not how it works. As lawyers, our job is to put our best, most professional fight forward for our client. And that's what we do for a living, or that's what many of us do for a living. It is not, and this sounds crazy to say, but you don't contract a lawyer, you don't retain a lawyer to win your case. You retain a lawyer to present your case in the best possible light. You retain a lawyer to provide you with that access to justice that lays in the courtroom, for example. So again, a lawyer cannot and should not be telling you with any degree of definitive certainty what the chances of you winning a case are, or especially that you're 100% going to win this case. Because they don't know that. There's no way they know that. The second thing a lawyer won't tell you, and this one you can understand why they wouldn't tell you, but it's not as much a taboo as the first one, is that you can negotiate your bill. It really is a telling truth, and it's the fact of the matter that the more sophisticated a client gets, the more likely they are to negotiate your bill. And isn't that funny? Because the more sophisticated a client is, chances are the better off they are financially as well. So you'd think, well, can't a rich client easily pay your bill? They can. However, they didn't get to being rich by being stupid. So that client knows the value of money, and they know to question every dollar you're looking at. Not in the annoying nitpicking sense, but in the overall business person's reality and attitude of everything's got a price. Let's find the right one between the two of us. There are clients that don't question the bill whatsoever. There are clients that don't know they can question the bill, and that's the reality. And think about it from a business perspective. Why would a lawyer tell you, when you look at my tab, you make sure you negotiate for you to pay me less money? I don't mind when a client, brings up price negotiations, because when I do my work, I record my times very carefully. I know very well the effort, the time, and resources I'm dedicating to a file. So when a client questions some of my billings, for example, there's always a little bit of conversation to be had, but it's never the case that I'm coming at it from left field, because, as a lawyer, I track my work very carefully. I also, depending on who I'm working with, am likely to give a discount up front, for example, because that makes people feel good, and that way that reduces the chance of that conversation later on, because you can say, what's the delta we're talking about? Is it like a 10% kind of thing? It's not going to be 50%, 100% overbilled, because that is in the land of the ridiculous. But if it's like a 5 or 10%, then you tell them, I already discounted you 10%. So now what's going on? Right? Like, there are ways to have that conversation while still being honest with clients. But a lawyer, I've never known any other lawyer that tells their clients or shares the reality that you can negotiate your prices. As a lawyer that's a human being and that's been a client to other lawyers, myself, every time I've received a bill, I've negotiated it. The third topic that a lawyer often won't share with you is that they've made mistakes in the past. And this one actually has some deep-rooted issues into the pressure and mental health matters that go into being a lawyer as well. It's so hard, it's a difficult profession, and it's one that comes with immense pressure from clients, from media, from the public, from public interest, and from ourselves. Most lawyers are really hard on themselves, and saying out loud that you've made a mistake in the past, when lawyers are inherently or tend to be a certain kind of personality, that's not easy for anybody to do, but especially for lawyers. However, I'm of the belief that sharing if you've made certain mistakes with your client, you're not going to share it in the sense of, last time I had a file like this, I was so out of it, the guy never stood a chance with me as a lawyer. I hope that's not the kind of mistake you're making. But if the mistake is in the sense of a learning experience where we filed this certain kind of motion and this other one should have been filed, or we found out that the matter should actually have been brought forward in court X as opposed to Y. That kind of learning experience, I think there is a way to communicate that to a client if they're coming to you with a file that's kind of like a trigger file for you, in the sense that last time you had that file as a lawyer, it turned out to be hell, you made mistakes, all of that. And you can communicate that to a client in an appropriate way and say, I know from firsthand experience how difficult what we're looking at is. In fact, last time I did it, it turned out to be so difficult that we had to relocate courts, for example. or we had to go through all of these motions or all of the steps, or the other side really caught us off guard with this argument. That actually, if communicated appropriately, conveys to you as the client that this lawyer is experienced and they know something about what you're talking about. Because if they weren't experienced, how would they have learned all of these life lessons, if you will, within the practice of law, of course? So that's something that I know, it's really something that a lot of lawyers keep hush hush in the community. They don't share things like that with their clients. They might share them with each other. However, I don't think that that's a topic where it needs to be hush hush. And again, here you'll notice my commentary. I'm telling you exactly as I feel, depending on the topic at hand. For example, with the first one about a lawyer telling you you have a 100% chance at something, no lawyer should ever tell that to you. But when it comes to, the pricing or the telling you that they've made mistakes in the past, I think that's okay if delivered appropriately. The fourth item, and this one is a serious one. No lawyer should tell you that they're the best at something. If you hear that, it's a red flag. In fact, for us, as I mentioned, Graphene Business Law is in the province of Ontario, so the jurisdiction is the Law Society of Ontario. There is explicit language in our rules of conduct, and I'm going to look down and say here, when it comes to marketing, for example, that no lawyer should make suggested comments that pertain to suggestive qualitative superiority to other lawyers. And the thing is, I actually know some lawyers that take that risk and they put, the best legal service. That is a red flag. There are lawyers in this province, there are lawyers in the world that objectively might be close to being the best at what they do. However, even to that, there's so many angles. To a certain client, the best lawyer is somebody that really listens. To another client, the best lawyer is the pit bull. To another client, the best lawyer is the guy that, regardless his personality, he's got the most experience in court. He's been to court more times than any other lawyer. To another client, the best lawyer is somebody that, is the most published figure on a topic, even if they've never been to court. That reality exists. So who or what does the best mean anyways is a question in and of itself, but also the inappropriateness of commenting on yourself as the best lawyer at what you do in an area where everybody or most people are working hard to represent client interests and to play within that ambit of the law. If you hear, again, a lawyer telling you that they're the best at what they do, that is not an appropriate comment. That to me is the reason to not work with that lawyer. And you could ask them, if you hear that, well, what makes you say that? How do I know you're the best at what you do? And they might cite, a blog or a rating or something, so many of which, by the way, people pay to be posted on. So easy with those, public best lawyer situations in the first place. However, it's still a comment that shouldn't be, it's a comment that shouldn't be made, period. If you're the best, the client's going to pick up on something. I have never told a client I'm the best at what I do. I've told them my approach when it comes to business law. I've told them my belief system. I've shared with them, my attitudes, and the fact that the only thing I can guarantee a client personally as Pam Matani, and not every lawyer can do this either, because not every lawyer has the attitude that I have, right? People are different personalities, this and that. I can tell a client that I'm going to fight for your case like it was my own. That's how I take cases on. Or if we're in the transactional drafting landscape, I'm going to draft and put the attitude and energy and resources into this agreement as if it was to defend my own business, okay? That's what you can count on when you work with me. I am going to fight this fight for you, okay? And with you, because I want you to win. But can I guarantee your win? I cannot. Do I have any business telling you I'm the best? No, I don't. Because when we're done working, it's on you to tell me, Pam, this was the best experience. Thank you so much. The fifth topic that I feel lawyers could be a little more transparent about is in the litigation scheme, in the ambit of litigation, what are the chances of something genuinely going to court, right? So when we think litigation, we think suing, we think lawsuits, and automatically court and the judge situation that we discussed earlier in this video. However, at least in the province of Ontario, and I imagine it's the same in the US, Australia, UK, all of that, 96, last time I checked, % of cases in the adversarial ambit, so I'm not talking about transactional, I'm talking about litigation-minded cases where we file the statement of claim and all that, don't make it to court. People settle, the system is overwhelmed, there's all sorts of external pressures, there's life realities, this and that. 96% of cases, again, last time I checked, don't make it to court. But I feel that some lawyers think that talking about court gives their clients a certain sort of impression, gets the adrenaline going, it might make them more likely to pay, you know, it taps into that emotional of like, yeah, let's fight, let's go to court. But litigation almost, I mean, with 96%, you can say almost none of the time, or doesn't involve that actual day in court. So I think it's fair to be honest with your clients about the fact that we are litigating this, but this is what that actually means. It means we're going to go through certain steps, and there's a 96% chance none of those steps will take us to that day in court in front of the judge. Again, it can be an emotional pull to make a client, you know, to prep them for court. Because court, with the movies and the media and this and that, represents fight. And you tap into that aspect where if they're fighting, they're funding you and this and that. But I think there needs to be some transparency around that as well. If you've made it this far in the video, I want to thank you for watching. If you have had experiences with a lawyer yourself where they've made any of these comments, let me know in the comments down below. How did you handle it? Your comments obviously help everybody in our little business law community here on Graphene Business Law on YouTube, and it's something others can learn from as well, because that's part of your life experience and your life lessons, and we'd love to hear that as well. Otherwise, if you made it this far, can you like this video more than once? Is that possible? Like, subscribe. Thank you so much for watching. We'll be back in a few days with more content for entrepreneurs and business owners just like yourself.